Another popular item that folks were interested to understand better is domestic violence. Now, that's scary in itself to potentially be charged with domestic violence, but there's two different places to sit on that situation. And also, don't talk, right? This is another shut up, start off. But then how does that work for someone dealing with domestic violence?
Domestic violence cases are really complicated. Obviously it has a bad stigma, of course. You hear domestic violence and, everyone, kind of looks the other way. But you'd be surprised, there's a lot of situations where, it's a married couple and, they've never had an issue before and someone drank too much and things got out of hand and someone got scared and called the police. But then, they settle, their differences, but the state's still wanting to prosecute. So we run into that, a lot where, a spouse or a boyfriend or brother or sister doesn't want to prosecute their loved one or their family member. However, the state still wants to pursue charges. So we deal with that quite often.
Do they get dismissed often, or what happens?
It's tough because the prosecutor's office, and different prosecutors' offices in Missouri, once they issue a domestic violence, they're not inclined to dismiss a case. So a lot of times you have to set it for a bench trial or a trial. If the alleged victim is not wanting to prosecute, that's typically how you're going to get your dismissal. Prosecutors are not willing to dismiss domestic violence charges once they've been filed.
Oh, they're weary of, they're weary that the alleged victim is coerced into or intimidated into prosecuting. That's kind of the rationale, I suppose. And in my opinion, prosecutors' offices, in many cases like this, I think you'd agree, is to create more harm and issues. Again, under Chris's example, a husband and wife, that have no prior issues, been married 15 years, and something got out of hand that night. Right. Not justifying it or that's saying that's acceptable, but they made up. They've are dealing with it in the home, but the police have been called, and sometimes they're very reluctant to dismiss, as Chris mentioned.
And once the call to law enforcement happens, it's over.
It's out of their hands.
Exactly.
Well, because we get calls, and how often you hear this is when you go, I don't want to. My husband doesn't want to prosecute. I said, I understand that, but it's not as simple just calling down to the local prosecutor's office.
Yeah, like they don't go, oops, oh, no problem.
Right. I mean, once those police get called, it's sort of out. It's not sort of. Yeah. It's completely out of their hands, of whether or not they want to prosecute. Now, then you get us involved or an attorney involved, and then there are certain things, like Chris said, setting it for a trial in which maybe the alleged victim doesn't show up to get the dismissal. But again, prosecutors are kind of weary of dismissing, kind of on the rationale of, well, is this alleged victim coerced or intimidated by the defendant into?
Well, I mean, it's commonplace, right?
It
kind of starts there, so right. It's scary to wonder,
right?
Is it that or is it not that? What about if the alleged victim didn't make the call? What if the neighbors made a call?
Same thing applies, really. I mean, once those calls are made and the police arrive, it's
the same old.
It's out of their hands. I mean, at that point they have to do their job, of course, and
which is find a reason to take you to jail.
Yeah, I mean, they're typically going to make arrests. I mean, the days of showing up and saying you get out of the house tonight and come back tomorrow. I mean, that doesn't happen anymore. I mean, obviously, domestic violence, and it's a real thing, and so once they show up, an arrest is typically made, and then. That's when we get involved.
So they don't do that thing. Is that called like the 12-hour rule or something like that?
And I guess some jurisdiction. I think that's a thing of the past, where of saying, hey, leave the house and spend the night overnight.
Or just pull down the block and park, and then as soon as we leave, you can come on back. You're good.
Right. And most of these things, I mean, let's face it, like Chris mentioned initially, most of these issues are as a result, not all, but many of them, as you'd see, and the majority of them are rooted in alcohol, a night out, infidelity. But alcohol and drugs is a big, initiator of
Sure.
domestic violence issues.
Right.
And so they're not going to put, hey, Mr. Drunk Guy back in that house. Or,
Yeah, no.
Hey, go cool off down the street.
Yeah, that was like
I mean, there's somebody's typically getting arrested.
that was a long time ago when they
Right.
were.
Yeah, it was
that's
the days
that's
of,
in rural, towns. Like go home, take care.
the days of getting pulled over and hey, park your car and
Call
call an
Right.
Uber. Or
Yeah.
cab,
That's
those
over,
days
and
are
then-
over, yeah.
You say dismissing cases is not often the case, but can you get them reduced? I mean, if they come in and say, I don't want to do this, I don't want to do that, I was drunk and stupid, can we not go through with this?
Or like, a case like, you could shed light on this, the case where the victim doesn't wish to drop the case, the alleged victim. At that point, it's like any other case. We're
Yeah.
trying to, we're evaluating the evidence. We're talking with our client, conducting our own investigation. Was this in a self-defense case? Did this person, did the alleged victim initiate it? And so we're looking at all that when we're looking, and sometimes, like you just mentioned, like motive-based too. Maybe they're in the middle of a child custody, and this has some sort of, there's a motive behind, making the call to police or something like that. And so we're looking at all these things when we're evaluating the case and reviewing the evidence.
It's important to know what you're dealing with.
Sure.
You guys have to do that, which
Absolutely.
you do it very well. Moving on to orders of protection. So I think a common aspect of that, at least in my thoughts, is like, when's it so far that I can stop somebody? When does it cross the line where an order of protection makes sense?
Well, unfortunately, it's the easiest. I'll maintain that it's the easiest thing in our judicial system to misuse, because it is. I could literally walk into St. Louis County Courthouse, leave here, walk in there, and say, I always use this. My wife hit me with a frying pan last night, and write that on a piece of paper. They'll send it through to a judge who will almost certainly say, issue what we call an ex parte order of protection, meaning that person will get served, my wife would get served, be removed from the house until there's a hearing. And it is so misused. And it's unfortunate too, because there's times obviously that people, real victims,
Sure.
these things are in place to move incredibly quick because somebody's in danger, whether it be an adult or a child. And so we need these things, and it's good to have, but it's also the most misused. In my example, I could do that. My wife would probably be served tonight, tomorrow, and out the house she goes until we have a hearing 3 weeks from now.
Oh my gosh.
And you see it all, and I see, and I do hundreds of these, and I probably maybe more than any attorney in the state. And you see people filing for the most frivolous reasons that aren't why this statute and the Adult Abuse Act were intended for. And so it's when they come to me, it's my job to kind of sift through that, and we're going to prepare for a hearing, because that's ultimately what a case like this culminates in, is a hearing to determine whether a full order of protection is granted.
Okay. That makes sense. So I guess the judgment call is, if you feel threatened, it's worth a call.
Well, sure, and they don't have to. In the Adult Abuse Act is designed for people to act pro se without an attorney. We probably handle 95% of what our firm handles is on the respondent side.
Oh, I see.
And that is the person being served. Now, we do, and we have multiple cases right now with a petitioner, person seeking the order of protection. But about 95% of our cases are dealing with the person who's served with the order of protection. And if it's reached that stage, you probably are not wishing to have contact with the person.
Right.
And I always say that to people. I said, this isn't about your relationship or wanting to have contact with the individual who served it on you, or filed it against you, I should say. This is about, this thing has real consequences.
Right.
If you get a full order of protection entered, this is on your permanent record.
Yeah.
As Chris said, nobody wants to have the stigma of being an abuser.
Right.
And these things have real stigma, and so people, I don't care. The worst thing somebody can do is say, well, I don't care that Jane Doe filed this against me because I want nothing to do with her, so I don't care. Well, that's fine, but this ain't about Jane Doe. This is about your future. This is about this thing being part of your permanent background. Again, if you go get a job, these things are major red flags.
Yeah.
They say, well, you got a full order of protection, which essentially means you are a stalker, a harasser, an abuser, or a sexual predator.
What a lot of people don't realize, and this is Steve's, expertise, these order of protections, but, I know a lot of people say they show up in court, they get served with a summons, they show up in court, and they don't realize that a custody decision can be made. They can be tossed out of their place of residence, their home.
Absolutely. And so these things have beyond just, hey, can I contact, so-and-so. These things have real consequences. We get calls, too, all the time, and it's after the fact. Well, I went into court. I didn't do anything wrong, so I didn't think I needed a lawyer. And they come out with an adverse ruling or slapped with a full order of protection. What can we do now? And there are some things, and we can explore an appeal and a motion to reconsider, but so, man, you make the call before. It's back to this. I'm innocent, so do I need a lawyer still? Well,
yes.
Absolutely. Maybe even more so if you're innocent.
Yeah.
Same thing, and that's the common mistake people make on these is saying what the person wrote in that petition isn't true, and I didn't feel I needed to get a lawyer. I'm in courtrooms 2 times a week at least on orders of protection, and I watch pro se litigants on both sides of the aisle, petitioner and respondent, and it usually just does not end well. Would you conduct your own surgery? No. Would you? No. I mean, I always say I wouldn't build my own deck. I can't. No. I'm not handy.
Yeah.
I'm going to call a carpenter.
Even if you were handy, you probably call somebody.
And so, I say that all the time. I say, just simply because it's not wise to go into any courtroom without an attorney. And so even if you think the truth is on my side, or I didn't do anything wrong, that is a common mistake folks make on these. And then again, they call us after the fact. They leave the courthouse in many cases, and they're on their way to, I got this order of protection. It's, BS. And, and there's things we can do, but it's a lot easier to do it before you walk into that courtroom.
Right.
And now they can enter them up to 10 years, which that's a new change in the law. As of a year and a half, 2 years ago, or a year and a half ago, it was 1 year. And so you could only get one for 1 year, and then the person can renew it. Now they can do it up. I have a case right now that we're appealing, and the individual that our client has a 10-year order of protection.
Oh my gosh! So
we are appealing it. In fact, we're the first appeal in the state of Missouri on this issue. So it'll be interesting to see what the Missouri Court of Appeals, how they handle this.
Wow!
Because there's been no appeal yet on this very issue on this 10-year.
Wow, 10 years.
10 years.
Like, why would you appeal it? Why would you? It's pretty obvious that person doesn't want to be around you.
Right, but again, it goes beyond that 1 year, 5 year, 10 year. It goes way beyond that. It goes on your record, real consequences. And we appeal we filed more appeals on order of protection cases, Combs Waterkotte, myself, our firm, than any firm in the state. I have, I think, 4 order of protection appeals going now. And if, just roughly speaking, we probably win at about a 50% clip, which is, it's 50-50 coin flip. The probably state average on an appeal is probably like 3% success rate.
I would say less.
Less
probably.
even.
Sure.
And so these are ripe for an appeal. I know the very issues to look at. We get a copy of the transcript, we dissect it, and we go, okay, they did not. This is the issue we're appealing on. There was insufficient evidence on X, Y, or Z, and we've been successful in appealing countless order of protection cases. And that allows the person to be restored to the position they were in prior to all this being placed on their record.
And back to what Steve was saying, just because, look, I don't ever want to talk to Jane Doe again, so I don't care. I'll just consent to this. Well, Jane Doe can call the police up and say, hey, just got, he's still bothering me. Then you're looking at criminal charges for violating an order of protection.
That's a great point that I didn't mention, is that it almost sometimes it weaponizes somebody.
Yeah.
Because it becomes very easy for that, like in the hood, Jane Doe, hey, he drove by my house in violation of this order of protection, and leading to a criminal charge.
Wow.
So there's a number of reasons that you don't, despite what your thoughts are on having contact with the individual, that you want to contest it.
Seems like
and hire a lawyer.
Seems like all in all, if you're involved at all with an order of protection, you should get an attorney.
Absolutely. Like I said, I see
it's
it
just silly.
Day in and day out, watching pro se folks on both sides, and I'm going, and it's bad. You don't want to go into court without an attorney.
No. Or even have something charged against you to any degree without an attorney.
Absolutely.
Someone to help you through. Absolutely. I don't know the legal system. Right. The last thing I want to do is go into a courtroom without somebody that knows it, which is kind of, when people seem to think that, it'll be fine, I'm innocent. But that's like, you just going to jump in a race car and join the Indy 500.
Traffic tickets.
You drive, right? You know how to drive, don't you?
Yeah.
So you could do the Indy.
I don't know about that.
But it's just typical. People just don't realize.
Even in like low level traffic tickets, someone it's not a big, in the grand scheme of things.
It is a big
traffic
deal.
ticket isn't a big deal, but you go in there and you pay it. Points go on your license. All of a sudden, your insurance rates go up. Right. Maybe you drive for a living, or use your vehicle, and your employer needs to check your driving record. It creates issues. So even the most minuscule of things, or minor things, can lead to real consequences. So we get calls like that too, like, hey, well, I just sent in my money and pled guilty with no attorney on a traffic ticket. Now my insurance rates went up, or my insurance canceled me.
Some people just get bad advice from law enforcement, you get pulled over and you get a speeding ticket and they say, oh, you don't have to go to court, just mail this in with the payment. Right. Well, when you mail that in with the payment, you're taking a conviction for speeding and points are going on your driving record.
Moral of the story, it's a lot easier calling the attorney than trying to undo what's been done.
Because you didn't call an attorney.
Exactly. Whether it's an order, whether it's a traffic ticket, because then we got to file a certain motion, it gets a lot more expensive, whether it's an order of protection case that you had an adverse ruling on, and they call us after the fact. It's a lot more difficult to undo. Yeah. Undoing in the justice system and in the judicial system is difficult.
Yeah, it's easier to catch it before you have to undo it.
And we give free consultations. It's not, we don't, charge for any kind of consultation. We talk to folks all the time, and it might not be a case that we can handle, or maybe they don't need it. Maybe they don't even have the legal issue that is currently cropped up, but it's worth a phone call.
For sure.
I think that's something that's unique to our firm too, is that we're very generous with our time. I know that, again, we are available, 24/7, but we're very generous with our time. And another great thing about the criminal defense business is we're not, a slave to the billable hour. So, I often tell clients, you're not paying me by the hour. If something's giving you anxiety, you got a question, pick up the phone, call me.
Right.
So